if they could dig the hole a little deeper in case Vanessa would be joining her.
He has 5 families, and now 5 families live with the consequences of this one man's continued disregard of life.
He threatened my life, so I said, well, I see you.
In May 2022, Carla Williams, a respected educator and fitness enthusiast, was shot down while working out at Pensacola Fitness. Her killer was her ex-boyfriend, Kenan Farrow, who entered the gym and fatally shot her. At the time of the murder, Williams had an active restraining order against Farrow, following a history of domestic violence, including a prior arrest for allegedly attacking her earlier that year. Despite the serious allegations, Farrow had been released on bond. The killing was a devastating act of premeditated violence, carried out in a public space and witnessed by others. After spending over 600 days in custody, Farrow was declared mentally competent in December 2023 and pleaded guilty to first-degree premeditated murder, violating a domestic violence injunction, and possession of a firearm as a convicted felon.
On your birthdays, you will ride in prison. On your Christmases, you will ride in prison. Your New Year's will ride in prison. And when your mom dies, you won't be there to comfort her. You will be riding in prison. You will rot and rot and rot in prison.
I never thought I would be asking, begging, and pleading for the impossible, just for my mama to come back. One more call, one more hug, one more text, just one more something. But not this.
During the sentencing, emotional statements were delivered by Williams' family, students, and even Farrow's own mother, who acknowledged her son's struggles, but also expressed sorrow over the loss of someone she once considered a friend. The courtroom was filled with grief and anger as loved ones remembered Carla and condemned the violence that took her life. On January 25, 2024, he was sentenced to life in prison without the possibility of parole. In November 2017, Aiden Von Grabo showed up at the home of Michaela Grote, a classmate he had become increasingly fixated on. Nicole wasn't alone. Her older sister, 20-year-old Michaela Grote, a college student and aspiring race car driver, was also there. When Aiden arrived, Michaela stepped in to protect her sister, and during the confrontation, she was fatally injured.
That's what she did on November 17th, 2017. She gave up her life to protect her sister, Nicole.
But I know she was a bright, kind-hearted person who put others before herself.
The incident shocked the Longmont, Colorado community and led investigators to uncover a troubling list in Aiden's possession, a document outlining the names of people he intended to harm, including Nicole and others from their high school.
A list that reads as follows: Nicole Grote / whomever is home. Torture till they crossed out she begs for mercy.
In court, Aiden eventually pleaded guilty to 9 of the 18 charges against him, with the rest dropped in a plea agreement. The courtroom was filled with emotion as Michaela's family shared their heartbreak.
There is no forgiveness. There never will be forgiveness. You took away a piece of my forever happiness. From this day forward, I can only hope and pray that you will live the rest of your life miserably.
Her mother called out the lasting pain of losing a daughter, while Nicole, overwhelmed by grief, had to step out during the proceedings.
I can't fathom losing my daughter the way that you did, but I am greatly sorrowful for it. And if I could put myself in her position, I would. I would. I swear. She didn't deserve to die.
Aiden's mother also addressed the court, expressing deep remorse to the Grote family. In July 2019, now 17, he was sentenced to life in prison with the possibility of parole after 40 years. The sentencing brought a measure of legal closure to a deeply painful and tragic chapter. In January 2022, Jon Tokuhara, a well-known Waipahu acupuncturist, was found shot to death in his clinic. Investigators quickly uncovered a possible motive rooted in a secret affair between Tokuhara and Joyce Thompson, the wife of Eric Thompson. Digital forensic analysis revealed over 5,600 messages exchanged between Tokuhara and Joyce in less than a month, pointing to an ongoing relationship.
And what was the general nature or character of these messages?
The context of the messages seemed to show that Mr. Tokuhara was involved in an affair. From the context of the messages, it sounded like the person he was involved with was named Joyce and her husband was named Eric.
Surveillance footage captured a man wearing a white bucket hat arriving at and leaving the clinic in a white truck. That hat, later recovered and matched to Eric Thompson through DNA evidence, became a crucial piece of the case. Prosecutors argued that Thompson acted out of jealousy and rage, deliberately targeting Tokuhara. Meanwhile, the defense attempted to raise doubts by questioning the timeline of death based on gameplay activity on the victim's phone.
It is possible that it got turned off.
It's possible.
What do you mean it's possible? Why is it not possible?
I just said it's possible.
In April 2025, a jury found Eric Thompson guilty of second-degree murder. During sentencing in June 2025, the court handed down a life sentence with the possibility of parole plus 20 years for firearm use, both sentences to run concurrently. He must serve at least 15 years before becoming eligible for parole, with credit for time served. On January 17, 2020, Colin Jeffrey Haney carried out a planned attack on his own family in their Grantsville, Utah home. Over several hours, he fatally shot his mother, Consuelo Haney, and 3 younger siblings, Alexis, Matthew, and Milan, as they returned home at different times. When his father arrived, Haney shot him during a confrontation, but the father survived and managed to call for help. Authorities quickly responded and took Haney into custody. The shocking case deeply impacted the Grantsville community and raised questions about mental health and juvenile justice. In 2022, Haney pleaded guilty to 4 counts of aggravated murder and 1 count of attempted murder. Prosecutors described the killings as premeditated and methodical, while the defense pointed to Haney's emotional struggles and efforts at rehabilitation.
I'm generally a glass half empty person, but I do have hope for him because I've seen so much progress from where he was.
The court handed down 4 consecutive sentences of 25 years to life, totaling 100 years for the murders, along with a concurrent sentence for the attempted murder of his father. The judge also ordered $28,000 in restitution. His parole eligibility will be determined by the Utah Board of Pardons in the years ahead. On the morning of December 6, 1984, Gloria Pointer left her Cleveland home excited to receive a perfect attendance award at school. She planned to stop by a friend's house to borrow a headband, but never made it to class. Hours later, her body was found near an apartment stairwell. The incident devastated her family and left the community searching for answers. Despite ongoing investigations, the case went cold for nearly 30 years. In 2013, a breakthrough came when DNA evidence from the original crime scene matched Hernandez Warren, a man already in the system for unrelated offenses. Warren was arrested and later pleaded guilty to aggravated murder and rape in a plea deal that took the death penalty off the table. During the emotional court hearing in 2014, Warren accepted responsibility and spoke directly to Gloria's mother, Yvonne Pointer.
I'm responsible, fully responsible for killing your daughter, Gloria Pointer.
Today, I don't have any thoughts about him. I choose not to utilize any space in my head with that individual, but I have no unforgiveness in my heart for him. I pray that he ultimately will be able to find peace with himself and his actions.
Though deeply impacted by her daughter's loss, Yvonne expressed that she chose not to harbor hatred, hoping instead for peace. Warren was sentenced to 30 years to life in prison, bringing long overdue justice and closure to a case that had haunted a family and city for decades. On August 16, 2021, Melissa Parker stole a Hummer from a Circle K gas station in Spartanburg, South Carolina. Moments later, she was spotted by law enforcement, and a pursuit began. In a reckless attempt to flee, Parker entered a 26, driving the wrong way at high speed. Just 10 minutes from reaching their hotel, 4 girls from Indiana, 2 twins, Eliana and Isabella Gaddis, Brianna Foster, and Macy Waltz were traveling together when Parker's vehicle collided head-on with theirs. The crash killed the Gaddis twins and Foster, while Macy Waltz was the only survivor, later found crying for help amid the wreckage. Parker fled the scene before being captured by police nearby. The solicitor described the collision as one of the worst he'd ever seen. Parker was charged with multiple felonies, including 3 counts of DUI resulting in death, hit and run, and grand larceny. In court, she pleaded guilty to all charges. The defense claimed she was experiencing drug-induced psychosis from a combination of Adderall and Delta-8 THC, though this failed to meet the standard for an insanity defense.
The brightest, most loving, perfect, like the joys of light, like their whole life was about lifting other people up. We all feel like we're dying. Like minute by minute, we feel like we're, not gonna be okay.
During sentencing, grieving family members and survivor Macy Waltz gave emotional statements, with Macy expressing that Parker would never understand the pain she caused.
Before the crash, we were all talking about our futures. And Brianna wanted to, she was talking about when she was gonna have kids. And Ellen and Bella were talking about where they were gonna move. And the fact that no, none of them get to do that.
The judge sentenced Parker to 25 years in prison and imposed over $75,000 in fines, $25,000 for each victim. The tragedy left families devastated and a community mourning the loss of 3 bright young lives. On January 30th, 2014, a routine welfare check along a rural Utah highway turned deadly when Sergeant Cory Wride of the Utah County Sheriff's Office stopped to assist a seemingly stranded vehicle. Inside were Megan Grunwald and her boyfriend, Jose Angel Garcia Waregi, who was wanted on a felony warrant. As Sergeant Wride approached, Garcia Joregi opened fire from the back seat, fatally injuring the deputy. Grunwald then led officers on a high-speed chase across multiple counties, while Garcia Joregi continued shooting, seriously wounding another deputy, Greg Sherwood. The pursuit ended near Nephi when law enforcement disabled the vehicle. Garcia Joregi was killed in the final standoff, and Grunwald was arrested. In 2015, Grunwald was convicted of aggravated murder and other charges, receiving a sentence of 30 years to life. However, in 2020, the Utah Supreme Court overturned her murder conviction due to improper jury instructions. Rather than face a retrial, Grunwald accepted a plea deal in 2021, pleading guilty to 2 counts of manslaughter and aggravated robbery.
I'm 21 years old now, and somehow I feel like I'm grieving my dad's death all over again. I remember calling my mom while she was at work. To this day, I can hear her hysterically crying and saying, "Dad has been shot. Dad is dead." I remember telling 3 of my 4 brothers the news. Not my mom, not the police, but 14-year-old me.
Sergeant Wride's daughter gave an emotional statement, recalling the pain of losing her father. Though Grunwald appeared emotional, the judge imposed the maximum sentence, bringing the case to a close. In September 2021, Megan Grunwald was resentenced to 30 years in prison. In May 2010, Westwood resident Lionel Dangerfield was left in charge of his girlfriend's daughter, Jimera, while the mother, Chania Binford, was away. The next morning, Binford found her girl unresponsive, lying beside her twin sister. Emergency services arrived, but the girl was already deceased. The autopsy revealed that Jimera died from severe injuries. Binford later testified that Dangerfield had abused the girl. The disturbing findings led to Dangerfield's arrest and formal indictment on charges including aggravated aggravated murder, murder, and felonious assault. Prosecutors sought the death penalty. During the trial, the defense presented no witnesses. After 6 hours of jury deliberation, Dangerfield was found guilty of murder and felonious assault, but not aggravated murder, sparing him a death sentence.
State is hiding the truth of facts behind false facts and peer pressure provided by the detectives while investigating and while intoxicated. And for that reason, I refuse to apologize for something that I didn't do.
Despite the verdict, Dangerfield remained defiant in court, refusing to apologize for the crime. He was sentenced to 15 years to life in prison. Nearly 15 years later, in 2025, his parole hearing reignited public attention. Jimera's mother and family members spoke out, expressing pain over the loss and concern about his possible release, firmly opposing any chance of parole for the man they hold responsible for the infant's brutal death. On Thanksgiving Day, November 22, 2018, 29-year-old Kelsey Berreth was last seen at a grocery store in Woodland Park, Colorado, accompanied by her daughter. That same day, she met with her fiancé, Patrick Frazee, who was the last known person to see her alive. When Kelsey vanished, concern quickly grew, especially after her phone mysteriously pinged in Idaho 3 days later, hundreds of miles from her home. As the investigation unfolded, law enforcement focused on Frazee, ultimately arresting him on December 21st. He was charged with first-degree murder and solicitation to commit murder and was held without bond. In the weeks that followed, prosecutors filed 2 counts of first-degree murder based on different theories, along with 3 counts of solicitation. The case took a chilling turn when Crystal Kenny, a nurse from Idaho, admitted to helping Frazee clean up the crime scene and dispose of evidence. Despite requests from Frazee's defense to impose a gag order and preserve all law enforcement communications, the judge ruled those requests unnecessary or overreaching.
They've got a lot of investigative leads, a number of interviews they want to do, a number of items they have to collect, and quite frankly, releasing all that information to the public could hurt their ability to do that investigation.
Prosecutors remained tight-lipped about key evidence, citing the risk to the ongoing investigation. A crucial preliminary hearing was scheduled for January 29th, where more details were expected to emerge. Until then, Frazee remained in custody as the case drew national attention. In November 2020, Michael Hirokawa was accused of a brutal assault involving the physical assault, sexual assault, and kidnapping of a woman at his rented apartment in Honolulu's Capitol Place. The woman, who had reportedly met Hirokawa earlier that evening while working at a bar, was found severely injured. The case quickly drew public attention due to the disturbing nature of the allegations. Hirokawa was arrested and charged with attempted murder, kidnapping, and assault. Prosecutors built their case around the violent details of the attack, alleging clear intent and extreme harm. The trial unfolded over several days in 2023, with the defense arguing that Hirokawa had been unknowingly drugged with Ambien and LSD, rendering him involuntarily intoxicated and unaware of his actions.
I mean, I think that's definitely one of the issues in this case, the main issue in this case. You know, it's been our contention that Mr. Hirokawa was involuntarily intoxicated, and we're glad that the jury.
His attorney, Alan Kaneshiro, emphasized that while the events were not denied, Hirokawa could not be held criminally responsible due to his mental state at the time.
The jury in this case find the defendant not guilty.
It's been tough, but he was very resilient. I'm sure he's happy that the jury saw things the way they did, and he's hoping to get back to his regular life.
I don't know if there's any particular part of your case you think was the strongest argument.
You know, I don't think, I think with this much evidence that the jury heard, they had to take a look at everything. It was a really large amount of evidence they had to take a look at, and we're just appreciative that they saw things our way.
On May 30th, 2023, after more than 2 days of deliberation, the jury returned a unanimous verdict of not guilty on all charges. The courtroom was filled with emotion as Hirokawa embraced his mother in relief. Though disappointed, the state attorney general's office acknowledged the jury's service and the outcome of the legal process. On October 5th, 2019, Lyric Lawson was asleep in her family's home on Cleveland's east side when a shootout erupted outside. In what authorities described as a drive-by shooting fueled by a neighborhood dispute, rounds were fired into the house. One of those struck and fatally wounded Lyric. Several other, including her sisters and cousins, were also in the home at the time, but survived. The incident left the community devastated and prompted a thorough investigation that led police to arrest Raisin Howard as a key suspect in the shooting.
Today. All right, on behalf of the state, we have Brian Radigan and Jeffrey Maver. Mr. Radigan.
Thank you, Judge. Your Honor, both of these cases have been fully pretried and all discovery has been exchanged. As part of those pretrial discussions, it's my understanding we have come to a plea agreement. That plea agreement would have the defendant withdrawing his fully entered pleas of not guilty and entering guilty pleas to the following counts. First, Your Honor, in case number 644-613, the defendant would plead guilty to count 2 as indicted, a felony of the 4th degree drug possession. As part of the plea agreement, in case number 644-613, Your Honor, the remaining counts against the defendant would be dismissed. Next, Your Honor, we move to case number 646-565. Again, Your Honor, this case has been fully retried. All discovery has been exchanged. As part of those discussions, Your Honor, we have come to a plea agreement in this case as well. The defendant would be pleading guilty to the following counts. First, Your Honor, at this time, the state would ask to amend count 1 from aggravated murder to murder in violation of 2903.02a. In addition to pleading guilty to the amended count of murder, Your Honor, the defendant would plead guilty to the 3-year firearm specification on count number 1. The state would then dismiss the 1-year firearm specification and the 5-year firearm specification. In addition to amended count 1, Your Honor, the defendant would then be pleading guilty to an amended count 5. The state at this time, Your Honor, would ask to amend count 5, attempted murder, by deleting the 1-year firearm, the 3-year firearm, and the 5-year firearm specification. In addition to that, Your Honor, the state would be adding a couple victims onto count 5. We would be adding Symphony Lawson, Jaylani Neal, Leilani Neal, and Harmony Lawson. Those are some of the victims that are named in additional counts, Your Honor. With that amendment, Your Honor, the defendant then would be pleading guilty to attempted murder, a felony of the 1st degree. In addition to count 5, Your Honor, the defendant would plead guilty to count 7, and we would amend that as well. The defendant would plead guilty after the amendment by deleting the 1-year, 3-year, and 5-year firearm specifications, meaning the defendant would plead guilty to a second count of attempted murder, a felony of the 1st degree.
In May 2021, Howard pleaded guilty to murder, 2 counts of attempted murder, and a firearm specification. He also admitted guilt in a separate drug possession case. As part of a plea agreement, prosecutors amended the original aggravated murder charge, and Howard was sentenced to life in prison with the possibility of parole after 23 years. On July 5th, 2019, a deadly shooting unfolded inside the Walmart on Whitehorse Road in Berreth, South Carolina. Just after 1:30 p.m., deputies from the Greenville County Sheriff's Office responded to reports of shots being fired. When they arrived, they discovered 45-year-old Michael Jason Deck lying on the floor, fatally shot. The suspect, later identified as 33-year-old Braylon Lamar Morris, had fled the scene but was arrested shortly afterward at a nearby fast food restaurant, less than half a mile away. Investigators quickly determined that Morris and Deck knew each other and that the shooting was the result of a personal dispute. Morris was charged with murder and possession of a weapon during the commission of a violent crime. Authorities noted the situation was not random, but rather stemmed from a confrontation between the 2 men. The following day, Morris appeared in Greenville County Bond Court. During the hearing, he was formally advised of his charges: murder, which carries a maximum penalty of up to 30 years in prison, and possession of a weapon during a violent crime, which carries up to 5 years.
And in writing. All right, Mr. Morris, you've been charged with murder and possession of a weapon during the commission of a violent crime. Murder is a felony which carries a maximum penalty of up to 30 years incarceration. Possession of a weapon during the commission of a violent crime is a felony which carries a maximum penalty of 5 years incarceration. and the victim's father is present. Is there anything you'd like to state, sir, or share with me?
I just wrote, I knew what line where he just completely murdered my son in the middle of Walmart. What was the reason?
Can I tell him why? I mean, I tell him why I would just straight up with a straight face, and I wouldn't disrespect him or be ignorant on camera or nothing.
All right. He's willing to answer your question if you're willing to hear him.
Hear what he said.
I said he's willing to answer your question if you're willing to hear him.
If I want to what?
If you want to hear him.
Yes, I do.
All right. Yes, sir.
The reason why I murdered your son, when I first met him, he was a good dude, he was solid, you know what I'm saying? His word was his bond. He introduced me to a poison Scotty Pope, his homeboy. His brother Scotty Pope. Well, he was a rotten piece of shit. He fucked all the way up.
All right.
So that's why he did.
All right.
That's why.
All right.
He threatened my life, so I said, well, I see you. It don't matter.
All right.
You know? I'm ready for all my consequences.
Mr. Mars.
You getting paid for it?
I'm paying right now. Cash money, my life.
You will pay.
Cash money.
Mr. Mars, that's good. All right. Mr. Mars. All right. Mr. Mars, at this level, I want to deny your bond, so there'll be a no bond at this level. The Circuit Court, the Court of General Sessions, will have to set your bond on this charge, so they'll notify you of the date and the time that they'll have your bond hearing. All right. Do you have any questions, issues, or concerns?
I'm good, man. Thank you.
Yes, sir. All right, Mr. Morris, she'll have some paperwork for you to sign at that window.
The victim's father, Mark Deck, was present in court and was given the opportunity to hear Morris speak. In an unexpected moment, Morris addressed him, claiming he pulled the trigger because Mark had introduced him to someone who, in his words, got him all the way up, suggesting a betrayal or setup. Given the severity of the crime and the circumstances surrounding it, the judge denied bond, ordering Morris to remain in custody while awaiting trial. The case proceeded slowly through the court system, and in 2022, it was confirmed that Morris's trial had been scheduled for October of that year. In February 2019, a routine eviction attempt in Seneca, South Carolina, escalated into a tense standoff involving Joshua Lee Underwood, a former Oconee County deputy. Deputies arrived at his apartment in the Crescent Point complex to serve eviction papers, but Underwood refused to accept them. As a result, a warrant was issued for resisting the service of legal process. When officers returned to execute the warrant, Underwood barricaded himself inside, prompting concerns that he was armed. Due to Underwood's past ties to the sheriff's department, the Oconee County Sheriff requested assistance from the South Carolina Law Enforcement Division, SLED. SWAT agents responded, and after hours of negotiation, Underwood surrendered peacefully. A weapon was recovered from the residence, which Underwood admitted was his. He reportedly told officers the weapon was not intended for law enforcement, but for use against the mother of his son, who also lived at the apartment. Marijuana was also discovered and turned over to narcotics investigators, though no immediate drug charges were filed. The following day, Underwood appeared in bond court. The solicitor clarified that the charge stemmed from resisting service of legal process, not a violent altercation.
I'd like to hear from the solicitor's office and the sheriff's department before I make any decisions regarding bond for Mr. Underwood.
Yes, sir. May it please the court, Judge, just to clear up any issues regarding the warrant, the warrant is resisting arrest. However, I think what Mr. Underwood's maybe misunderstanding about that is that the resisting arrest also encompasses resisting the service of process or a writ. That is the specific portion that is being dealt with in this particular case. This situation arose when representatives from the sheriff's office went out to the residence where Mr. Underwood was staying and attempted to serve him with paperwork for an eviction. Mr. Underwood refused to accept that paperwork, so at that point, officers came back, obtained that warrant, and went back to serve that warrant. So that's how we got to where we are with regard to the warrant. Living with him at that residence, and I believe the primary person at that residence is the mother of Mr. Underwood's child. I don't believe they're married, but they do have a child in common. Certain statements were made while the situation was going on yesterday with regard to the standoff. A gun was obtained by law enforcement at the time of the arrest. Mr. Underwood did say that was his weapon, and intimated to officers that it was not for use on officers, but it was for use on his child's mother. Given those circumstances, there was also some marijuana in the residence that was turned over to narcotics as well at the time of the arrest. I don't know that any charges have been made with regard to those drugs. That's something that we'll be dealing with at a later date. But for today's purpose, what the state would be asking for is a cash or surety bond. We would request a bond of approximately $50,000. And we also believe that based upon the statements that Mr. Underwood has made, intimating potential harm towards his child's mother, we believe that GPS monitoring, ankle monitor, is appropriate in this case. We would also ask that the bond specifically include provisions prohibiting him from going to her place of work and to her residence. And certainly we can furnish the addresses to the monitoring company so they can go ahead and plug that into the monitor so they'll be notified if Mr. Underwood goes to either of those places. I think that's all we're asking for today. Any other issues certainly can be taken up at a preliminary hearing or at the appropriate time later on.
Okay, thank you.
Thank you.
Officer McCreary?
Citing Underwood's threatening statements and the presence of a firearm, the prosecution requested a $50,000 bond.
All right, Mr. Underwood, I find the solicitor's request for a cash or surety bond of $50,000 to be reasonable. Accordingly, I'm going to impose that cash or bond for your release.
I find it absurd that you haven't even obtained any information from me based off the solicitor. You're going to believe everything that he says.
Okay.
And you're going to go ahead and set a surety bond on me on a misdemeanor.
Okay. Are you finished? Okay. If you'll hear me out, please. Thank you. Additionally, I'm going to place a requirement for a GPS monitor prior to your release on bond. I'm going to restrain or restrict your contact with your domestic partner or the mother of your child, whichever best describes her, to include her place of work and her residence. Additionally, I'm going to prohibit your physical or constructive possession of firearms or ammunition at any time for any reason. And I want to make sure that you understand, when I say constructive possession, I mean there's to be no firearms or ammunition in any vehicle you're being transported in or riding in unless it's...
What grounds? Are you prohibiting me from firearms?
I am.
Why? What grounds?
I am. Because I have that latitude given the severity of...
What reason is your
Sir.
Why are you standing behind it that you're gonna
Mr. Underwood,
firearms?
Mr. Underwood, in this court, one person talks at a time.
From the solicitor's office and the sheriff's office.
You're going to find yourself in contempt of court.
I've already been in contempt.
Okay.
I'm not here, sir.
All right. Are you going to allow me to finish? Constructive possession of firearms or ammunition means you will not have it in your possession. It won't be in the house or the room that you're staying in. It won't be in the vehicle that you're being transported in, unless we're talking about transport by law enforcement. Do you understand that? All right. That's all. You're dismissed. Officer, if you'll remove him.
You can't look at me, can you? You can't look at me, can you? Which one? Which one?
Do you have any questions?
No, sir.
Okay, sir. Okay, thank you.
The judge granted all conditions, also prohibiting Underwood from possessing firearms or ammunition in any capacity. During the hearing, Underwood repeatedly interrupted, prompting the judge to warn him against further outbursts. The hearing concluded with Underwood being escorted out of the courtroom by officers. As of now, no public records or news reports indicate any further legal developments in Underwood's case following the February 2019 bond hearing. On the evening of July 4th, 2025, tragedy struck in Greenville County, South Carolina, when Kevin Clinton Harrison ran a red light at the intersection of Old Easley Bridge Road and Whitehorse Road. Driving a Jeep Cherokee, he collided head-on with a Toyota Camry carrying 5 girls. Among them was Chassity Unique Nelson. The crash left all 5 girls seriously injured, with Chassity in critical condition. She was rushed to the hospital, but despite efforts to save her, she passed away 4 days later, on July 8th, from injuries. The Greenville County coroner confirmed her death, and the emotional weight of the loss quickly rippled through her family and the community. Following the crash, Harrison was arrested and charged with 1 count of felony DUI resulting in death and 4 counts of felony DUI with great bodily injury. At his bond hearing on July 10th, family members of Chassity and the other victims delivered powerful impact statements.
Who's going to speak for the family?
I am.
You go ahead, make your statement.
Your Honor, on behalf of the family, I would like to honor and educate you about the life of 18-year-old Chassity Coral, a beloved daughter, sister, niece, granddaughter, and devoted friend. Chassity was a one-of-a-kind woman who lit up every room she walked into. She was quiet in nature but full of purpose. She was compassionate, kind, and deeply driven by her dream of becoming a veterinarian, dedicated for caring both for people and animals. As an honor roll student at Jailman High School and a vibrant cheerleader, her joy, laughter, and leadership brought unity to her team and inspiration to her peers. Her radiant spirit, her loving heart, and remarkable presence left a lasting impact on everyone that she knew. Chassity Cruel was not just a student, she was a role model. She was a beacon in her community and a future leader. Her life was stolen way too soon by Kevin Harrison. Kevin Harrison is not a first-time offender. He's a repeated danger to society. His willful disregard for the law this time resulted in the death of a vibrant girl. Because of Kevin Harrison, a mother will never be able to feel her daughter's arms wrapped around her again. A father will never be able to walk his daughter down the aisle. A grandparent has lost the joy of watching their granddaughter blossom into the woman they knew that she will always become. A sister will go back to college without knowing the one person that believed in her is gone. A brother will walk back into campus knowing that his biggest cheerleader is no longer there to celebrate his wins. An entire community is grieving the loss of a young life full of promise that was taken way too soon by someone who chose recklessness over responsibility. He has shared 5 families, all of whom now carry the heavy weight of trauma in every form, mental, emotional, and financial. And this is not just about accountability, it's about protecting other families from this pain. This was not an incident, it was a choice. And now 5 families live with the consequences of this one man's continued disregard of life. We are asking that this court truly hears us and see the magnitude of what is lost. We are pleading for justice, justice that is swift, justice that is fair, and justice this time that is effective. Not just for Chassity, but for every family now carrying the weight of this tragedy we have that should have been and could have been prevented. Kevin Harrison should not ever be awarded the opportunity of bond. Let this be the last time his negligence is allowed to destroy lives, and let justice speak clearly that Chassity's life mattered.
May I say, Kevin? Kevin? No,
you can't talk to me.
Your Honor, you can direct it at me.
Yeah.
Kevin, I researched you. I know you're a man of God. I know you're a man of God. Just as I am as a mother. I'm a woman of God. I raised her. I raised her to love and care. You don't know what you did wrong. You don't know what you did wrong. And I know that. I know that. And I just hope God have mercy on your soul.
I just want to say, he wrote.
I want you to direct.
I'm sorry. He wrote. You rode in the ambulance with my baby to the hospital. You not only my baby in the ambulance, the things you said to her on the ride to the hospital. My baby got to live with that for the rest of her life. She was the only one that wasn't sedated. And she told me to tell you, she forgive you, but she's angry with you.
I'm not gonna speak. You broke all of us on a day that's supposed to be joy. You're hurting all these families. These kids have lived there for the rest of their life. They lost their best friend, their sister, because of something careless and senseless. These girls have to go through recovery. You don't have to do nothing. They have to learn how to walk, talk, write again. And it's not fair. It is not fair. You could have Ubered, you could have Lyft, you could have called somebody. You could have sat at home. You didn't even have to leave. That is wrong. 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 Now when these girls get up, we have to give them that news that they lost their friend.
Chassity was remembered as a quiet yet purposeful girl, an honor roll student at Jailman High School, and a cheerleader. She dreamed of becoming a veterinarian and was deeply devoted to helping others. Her death was described not just as a loss to her family, but to the entire community. Her mother and relatives spoke about the lasting emotional scars, recalling the moment Chassity, conscious in the ambulance, endured the trauma of Harrison's presence and words. Though she had expressed forgiveness, the pain remained. The family pleaded with the court for justice, urging that Harrison not be granted bond and emphasizing that his actions were not a mere accident, but a choice that destroyed lives. The judge ultimately denied bond, and the courtroom was left with the haunting reminder that Chassity's life, full of promise, was stolen far too soon. In the final weekend of September 2024, chaos unfolded on the streets of Cleveland when a series of coordinated street takeovers gripped the city between the night of September 28th and the early hours of September 29th. These gatherings involved over 80 vehicles blocking intersections, performing reckless stunts, firing weapons and fireworks at law enforcement, and even pouring gasoline onto Interstate 90. Investigators later identified 23-year-old Ashlyn Rogers of Port Clinton as the key organizer behind the events. Using multiple Instagram accounts, she had promoted the takeovers, shared real-time updates, and directed participants from one location to another. Weeks later, on October 22, 2024, Rogers was arrested at her home by Cleveland's Street Takeover Task Force. She was formally charged with aggravated riot, disrupting public service, and possession of criminal tools. As her trial began on June 11, 2025, she entered a plea agreement. In exchange for pleading guilty to the first two charges, the third was dismissed. Rogers also agreed to forfeit her 2020 Infiniti Q50 and a cell phone to Cleveland police as part of the plea. On July 15, 2025, she appeared before Judge Kira Kravash in Cuyahoga County Common Pleas Court for sentencing. Rogers addressed the court with a prepared statement, taking full responsibility for her actions and expressing deep remorse.
Ms. Rogers, is there anything that you wish to say or present today to the court before I impose your sentence?
Good afternoon. I just wanted to thank you for allowing me the chance to speak today. I want to express that I take full responsibility for my actions. I understand that what I did was wrong, and I deeply regret the choices that led me here. I'm not here to excuse or minimize my actions, but to express my sincere remorse and to take accountability for the harm that was caused by my choices. I specifically want to apologize to the community members who were affected by my actions, as well as the involved law enforcement and other individuals who helped restore order the day of the incident and the days after. I know what I participated in was wrong, and if I were on the other side of it that night, I'd be very frustrated. This experience has been eye-opening and humbling. I've had time to reflect not only on what happened that night, but on the direction of my life, the people I've disappointed, and the person I want to become. I've taken many steps toward bettering myself, including individual and group therapy, support groups, personal reflection, and surrounding myself with better influences. I'm committed to continuing that growth regardless of the outcome today. I understand the court has a responsibility to ensure justice, and I respect that entirely. I only ask that you consider my willingness to change, my support system, and the progress I've already begun to make when deciding my sentence. I'm not the same person I was on September 28th, and I hope you can see that I'm working hard and doing everything I can to be better for myself, my family and friends, and for the community. Thank you again for your time and willingness to give me my statement.
She emphasized that the experience had been a turning point in her life, noting that she had since engaged in therapy and made efforts to surround herself with more positive influences.
All right, so what the court's inclined to do is, for starting with count 2, disrupting public services, the court is going to sentence you to the maximum amount of time, which is 18 months in prison. There was also a specification for forfeiture of property on that count, which would be the forfeiture of the 2020 Infiniti Q50 with a VIN number JN1EB7AR5LM250122, as well as a cell phone to be forfeited to the Cleveland Division of Police. As for count 1, the court is going to sentence you to the maximum amount of time in prison, which is 12 months in prison. Those sentences will run concurrent. Those also, count 1 also carried the specification for forfeiture of property with regards to the 2020 Infiniti Q50 and the cell phone. So those will be forfeited to the Cleveland Division of Police. Counsel, you also previously stated there was a 2-day jail credit. Does that sound accurate to the attorneys?
Yes, Your Honor.
Yes, Judge.
So we'll give you credit for 2 days in jail as approved by law. Counsel, did you wish to be heard with regards to court costs and fines?
I would simply ask the court to consider waiving them, Your Honor, at this time. Yes.
Okay. Are you asking for a finding of indigency?
Yes, Your Honor.
Okay. The court will make a finding of indigency. I think we've addressed the previous plea conditions, which were the forfeiture of both the vehicle and the cell phone to the Cleveland Division of Police. There is a 2-day credit in jail. So I also have to address with you post-release control. Since you are being sentenced to prison, upon completion of your prison term, you may or shall be subject to post-release control for up to 2 years as determined by the parole board pursuant to Ohio Revised Code 2967.28. And that's up to 2 years at the discretion of the parole board and not of this court. If you are placed on post-release control and you violate, the adult parole authority is authorized to return you to prison for up to a maximum of 1/2 of the original sentence imposed. If you're convicted of a new felony while on post-release control, in addition to being punished for the new offense, the judge could add an additional consecutive prison term of 1 year or whatever time remains on your post-release control term, whichever is greater as a maximum. While you're on post-release control and you fail to report to your parole officer, you could be charged with escape, which is a felony. If you violate any post-release control rule or condition, you may be subject to a more restrictive rule or condition, a longer duration under supervision, or you could be sent back to prison even though you have done all of the time in which you have been sentenced. You could get up to 9 months in prison for each rule violation. The total, however, for all rule violations cannot be more than 1/2 of the prison sentence you receive unless the rule violation is for the commission of a new felony, in which case you could receive a prison term of the greater of 1 year or the time remaining on post-release control, in addition to any time you receive for the new felony. The post-release control prison term must be served consecutively to any prison term you receive for the new felony.
After reviewing the case details, pre-sentencing reports, and letters of support, Judge Krivosh sentenced Rogers to 18 months in prison for disrupting public service and 12 months for aggravated riot. However, the sentences were ordered to run concurrently, meaning she will serve a total of 18 months. The court also granted her 2 days of jail credit and waived court costs after finding her indigent. Upon her release, Rogers will be placed under post-release control for up to 2 years, with conditions set by the parole board. Her sentence, the judge noted, was designed not only to punish, but also to support rehabilitation while protecting the public from further harm. In December 2019, tragedy struck the Holloway family when 43-year-old Christine Holloway was found brutally murdered in her Ansonia, Connecticut home. Her daughter, Vanessa Morales, was missing and has never been found. The shocking discovery set off a years-long search for justice and for answers. Authorities quickly focused their investigation on Jose Morales, Christine's boyfriend at the time, and eventually charged him with her murder and evidence tampering. Over the years, the case moved slowly through the court system, marked by grief and unanswered questions. Morales maintained his innocence, claiming intruders were responsible. However, in April 2025, a jury found him guilty. His story was rejected in the face of overwhelming evidence, including Christine's remains being found in her apartment. The horror of the crime left a deep emotional scar on everyone who loved her. At Jose Morales' sentencing, Christine Holloway's aunt, Anna Radonsky, gave a heart-wrenching statement describing Chrissy as a loving, devoted woman. She shared painful memories, including helping plan a funeral while Vanessa remained missing. Cleaning Christine's apartment later revealed traumatic truths, including the condition of her remains.
My name is Anna Radonsky, and I am the youngest of 6 children. Christine Holloway is my first niece. I called her Chrissy. Debbie, Chrissy's mother, is my oldest sister. My other sister, Kathy, died at 34 years old of lymphoma, and that was the worst day of my life. I didn't think I would experience another worse day like that. However, my beautiful, brilliant, kind, caring, spiritual niece was brutally murdered on 12/2/2019. How does one even begin to start to tell how this has affected my life as well as our family and friends? I would like to start with some background about Chrissy. She was the first person in our family, in her family, to obtain a bachelor's degree. She and I shared a bond with our faith. I chose Christina as my confirmation name because I loved her so much. She loved children, she loved her job, and taking care of so many adorable children at the daycare where she was employed. She was passionate and full of love. I moved to Nashville in October 2019 for a new job, and Chrissy and I would FaceTime with Vanessa during bath time or dinner. We supported each other's passions. She would open the freezer door while Vanessa was playing with her toys, and as soon as Vanessa heard the freezer door opening, she knew it was frozen mango time, and she would crawl as fast as she could, giggling all the way. I hope wherever she is now, she is still enjoying her frozen mangoes. On 12/2/2019, Chrissy was taken away from us, and Vanessa has yet to be found. My sister, Debbie, was left devastated and in shock. They say the worst pain is a mother losing their child. I watched my mom suffer through the loss of my sister, 34 years old, and now I watch my other sisters suffer through that same loss without Chrissy, and then some, with Vanessa still missing. Not to mention that 8 months after Chrissy was murdered, on August 7th, 2020, my oldest nephew, Chrissy's brother, Jon Holloway, lost his battle with gastric cancer, leaving his daughter behind for us to raise. Again, my sister lost another child, and Vanessa is still missing. I moved my mom from Connecticut to Nashville with me to get her away from all of the news and media in Connecticut because it was just too much for her. Chrissy was her first grandchild, and her great-granddaughter is missing. I listened to her cry, and we would hold each other as tight as we could, and the tears would continue and continue. There is nothing to say, just tears. She would say, "Anna, why? Why?" There is no answer, still no answer. My mom is my best friend, and she passed away in August 2023 at 97 years old. I wanted her to stay here forever, but I'm grateful that she didn't have to witness this trial. I know she is in heaven with her husband and my sister Kathy and Chrissy and Jon Holloway, and I know that they are taking care of each other. In preparation for Chrissy's funeral, our family tackled it as a team. We each had a job to do, and my task was to go to the Gates of Heaven Cemetery and make the arrangements. As we drove that day, so many thoughts were going through our hearts and souls. Vanessa's still missing. When we arrived at the cemetery, we were welcomed by the staff with opening and caring arms. We had to ask them if there is a way they could dig the hole for Chrissy a little bit deeper in case Vanessa had to join her. Let me repeat that. We had to ask if they could dig the hole a little deeper in case Vanessa would be joining her. Nobody should ever have to think about asking that question. Nobody. How does one go on? I recall packing my suitcase to come home after Chrissy was murdered.
Anna now lives with PTSD, but continues searching for Vanessa. In court, she called the crime unforgivable and hoped Morales suffers every day in prison.
The impact of this crime, of the defendant's conduct within our society is profound. A vicious crime such as this severely impacts the overall feeling and safety in our society. Society should not have to fear such careless indifference to human life. It makes you question who really lives next door to you. Christine had the right to be safe in her relationship with her young daughter's father, safe in her own home. This was a cruel, intentional, senseless, violent act. The defendant must be deterred from ever committing such an act again, and the sentence imposed must reflect the court's intention to deter generally such violent, senseless acts from happening in our society. The facts of this case, along with your criminal history, Mr. Morales, leave this court to believe that you have no regard for the rule of law and a callous disregard for human life. Your record clearly establishes that prison sentences, probation, and special parole do not dissuade you from committing future crime. Any consideration to be given to the aspect of rehabilitation in this case pales in comparison to the severity of these crimes. Mr. Morales, you are a dangerous person, a significant threat to society, and you need to be removed from the community for a substantial period of time. The victim's family, as well as the members of society, expect the guilty to be held accountable for their actions and rely on the criminal justice system for some measure of closure. No sentence or comments by the court will lessen the profound sense of loss caused by your actions. But you, Mr. Morales, will be held accountable and sentenced accordingly. Mr. Morales, please rise. Upon the court's considerations as outlined on the record, the following sentence is hereby imposed. As to the finding of guilty of the crime of murder of Christine Holloway, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 60 years to serve, which in accordance with our statutes is defined as life. As to the finding of the crime of tampering with physical evidence, it is the sentence of the court that you be committed to the custody of the Commissioner of Corrections for a definite period of 5 years to serve, to run consecutive to the sentence on the murder for a total effective sentence of 65 years to serve. At this point in time, I'm going to note your right to appeal. I'm also going to note that Connecticut General Statutes 1898E does not render you eligible for risk reduction credits on the murder, that 60-year sentence imposed. You may be eligible, however, pursuant to our statutes, if applicable, to earn risk reduction credit on the sentence imposed on tampering with physical evidence. Total effective sentence, 65 years. Court's going to waive any costs and fees for good cause in view of the lengthy incarceration.
The judge sentenced Morales to the maximum 65 years in prison, 60 for murder and 5 for evidence tampering. He declined to speak at sentencing. Christine's family, dressed in shirts bearing her photo and Vanessa's silhouette, stood strong in court, demanding justice not only for Christine, but also for the girl still missing. Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.